Hello guys, my name is Musawenkos Nyangani. So my presentation today is mainly focused on prescription in delict. So what is a prescription? A prescription is an old debt that arises when a debtor is no longer required to pay off their debt. It is a major defense in court in civil actions on a claim after the expiry of a certain period of time. In Zimbabwe, it usually has a period of 3 years when it comes to a prescription of delict. However, Section 14 sets out a longer period for prescription for a certain debt, which is 6 years for a debt owed to the state. Debts owed by the state which arise from a loan, sale, and lease of land are usually prescribed after 15 years of time. The prescription number 31 of 1975 specifies the delictual action prescription period. The term debt is defined in Section 2 to include a delict, while Section 14 specifies the prescription period for debts. The typical prescription time for a delict is 3 years. However, Section 14 specifies lengthier prescription periods for specific forms of debt, such as 6 years for a debt owing to the state. A claim for money owed to the state shall be made with 60 days notice in accordance with Section 5 of the State Liabilities Act. The notice must outline the claim's justifications, identify the officials involved when relevant and practical, and be accompanied by copies of pertinent documents. When there has been substantial compliance with the section, or when there has not been an unjustified harm to the state or the officer who is being sued, the court shall have the authority to excuse failing to provide the appropriate notice. The Police Act contains specific provisions addressing the statute of limitations for lawsuits arising out of crimes committed by police officers. The text of Section 76 is as follows. Any civil action brought against the state or a member regarding anything carried out or neglected to be carried out in accordance with this Act must be brought within 8 months of the cause of action's emergence, and notice in writing of the civil actions and the grounds there must be given in accordance with the State Liabilities Act prior to the action's commencement. In the case of Nika and another versus Minister of Home Affairs, the court held that claims against the police should be governed by the general year prescription time for ordinary debt as stated in Section 15D of our Prescription Act. It determined that the clause allowing for the shorter period of prescription for actions against the police violated Section 69 subsection 2 on the right to a fair hearing and Section 56 subsection 1 on the right to equality before the law and equal protection of the law. In accordance with Section 175 subsection 1 of the Constitution, it referred the case of the Constitutional Court for confirmation or disapproval of this constitutional finding. It is also important to take note of Section 176 and Section 178 of the Customs and Excise Act. In accordance with these, actions against custom officers under this Act must be brought within 8 months and 60 days notice of the intention to bring action must be given. A good example is the case of Badenhorst versus Minister of Home Affairs. It is very likely that the decision in Nika and another versus Minister of Home Affairs, which shortened the terms of prescription for lawsuits against police personnel, would also apply to lawsuits against custom officers. In other words, the reduced prescription time is also against the law. Section 25 of the Road Traffic Act should be carefully noted as it stipulates the following in relation to statutory third-party insurance claims. After 2 years have passed since the date the claim first arose, the right to sue the insurer directly should become barred. However, the claim against the negligent driver only becomes admissible 3 years after the claim first arose. So my question now is, when is a prescription delayed? A prescription can only be delayed when the creditor is a minor or is under a curator, when the creditor is mentally ill, when the creditor is out of the country, when both the creditor and debtor are spouses, and when the creditor is deceased. In light of the presentation, it is also crucial to remember that a patient's prescription does not start to run against him while he is non-compliant as a result of injuries. If the impediment is removed, the creditor may take legal action up to a year following the removal of the impediment. The hindrance has no impact on the running of the prescription if it disappears more than a year before the conclusion of the typical presentation duration. This is so that the creditor will have 1 year to file a prescription after obstruction was removed. According to the law, you are not required to pay the debt once it has become legally mandated. The interruption of prescription occurs when the debtor expressly admits in writing that they are responsible for the debt, or when the debtor is served with any legal document by the creditor demanding payment of the obligation. The judicial interruption process is another name for this process. In other words, the onus is on the debt collector or lawyer to recover money owed to them within a certain time frame and not postpone recovery so much that it accrues astronomical amounts of interest and fees. Therefore, it is crucial to further emphasize that acknowledging debt is one of the tools for stopping prescriptions. Unless the acceptance of debt is accompanied by a written extension on the day of the obligation becomes due, the term for prescription starts to run from scratch. According to the authors of the law of contract, a partial acknowledgement of liability interrupts prescription with respect to the debt as a whole, and that to interrupt prescription. The acknowledgement must be made by the debtor or by an authorized agent and only to the creditor or agent. According to the authors of the law of contract, a partial acknowledgement of liability interrupts prescription with respect to a debt as a whole, and that to interrupt prescription. The acknowledgement must be made by the debtor or by her authorized agent and only to the creditor or agent. Lastly, according to the legislation, prescription may be used to acquire both movable and immovable property. A person acquires ownership of anything by prescription if they have publicly and as though they were the owners of it for a continuous 30 years. Such a period, along with any other stretches during which the thing in question was so legally owned, make up an uninterpreted 30 years period. The Supreme Court of Appeal upheld the position that a claim for vindication cannot be classified as a debt in the case of Absa Bank Limited versus Keith, which included the ownership of a thing. Therefore, it follows that such a claim prescribes after a period of 30 years of continuous time rather than after 3 years of the debt requires.